In the wake of Chief Justice David Maraga advice to President Kenyatta to dissolve Parliament following its failure to pass two-thirds gender rule, mixed reactions are continuing to be elicited as constitutional experts stumble upon each other in a bid to give interpretation on Maraga's advisory. Tweet after tweet displays a picture of lawyers trying to outshine each other over the latest debacle and its interpretation. In the advice, Maraga cited Article 261(7) of the Constitution that provides that if Parliament fails to enact a law in accordance with orders directing it to take steps to ensure that the required legislation is enacted, the Chief Justice shall advise the President to dissolve Parliament and the President shall dissolve Parliament.
The 11th Parliament had already come to an end and we had gone for elections. And so the question was whether the order that was made by the Court of Appeal in 2018 was in respect of the 11th Parliament, which term ended in August 2017, or it also applied to the 12th Parliament, which has only been in session now for 3 years.
Once again, the ambiguity of the 2010 Constitution coming into play as it does not stipulate the time frame under which the Chief Justice advice should be taken into consideration.
The President has not been given an express or explicit time limit by Article 261 of the Constitution within which to act. And this is not the only occasion where the Constitution has failed to give a specific time limit to the President. We have seen the other case being where the Judicial Service Commission recommends names of judges for appointment.
Whereas the Law Society of Kenya, through its chair Nelson Harvey, have remained vocal that President Kenyatta will have no choice but to dissolve Parliament, failure to which laws passed through the same House will not be viable. Contrary opinions are being raised over the same, with pundits arguing that President Kenyatta is not bound to the advisory from the Chief Justice.
The advice of the Chief Justice is not operational. It is an advice to the President to act. So if the President fails to act, then there is no impact on whatever proceedings or processes or actions or acts that are undertaken by Parliament.
But what happens if President Kenyatta fails to heed to the judicial head advice to get rid of the 11th Parliament?
Someone can go to court to seek orders either to get the President to do it or to get orders to have that act that the President was required to do to be deemed to have taken place despite the failure of the President to do it.
Of more concern is the current time frame of political activities in the country, with the 2022 general election falling into place in 2 years' time. Martin Opio, K24.